we're back, and are you ready, Mr. Victorious?
Thank you.
Thank you.
Mr. Chair, if we may start today by just informing the public generally of where the evidence leaders' plans stand for the moment, and to place the intentions of the evidence leaders over the next few weeks and months into a particular context. We will then deal with the preliminary matters relating to the witness to be called this morning.
Yes.
So, DCJ in the chair,
Can I just confirm that everybody, particularly back and here already, I see heads being shaken, so they can't hear at the back. Does anybody know what's supposed to be done for everybody to hear? Can you hear now? Can you hear now? Yes, thank you. Okay. Yes, Mr. Victorious.
This is the first session of 2019, Chair, and it's perhaps apposite, therefore, to record the planning of the legal team for the first months, at least, of 2019. As we said in the opening address of the legal team, which in fact remains a good reference source for understanding the contexts in which our evidence is given, we are governed by our terms of reference. In general terms, term of reference 3.1 or term of reference 1.1 to 1.3 deal with appointments and dismissals of ministers, state functionaries, office bearers, and undue influence exercised in respect of these appointments and dismissals. The focus in particular is on the influence exercised by the Gupta family, but our terms of reference are not restricted to that. These terms of reference, Chair, deal with any form of undue influence. The words used are inducement for gain over ministers, office bearers, officials, and personnel of state-owned entities. They also deal with issues of governance. So the evidence to date has largely been focused on these issues, but that evidence is not complete, Chair, and there will be occasion during the next few weeks in particular, and perhaps even later than that, where there will be further evidence in relation to those terms of reference which deal with appointments, dismissals of government officials, ministers, and issues of governance, particularly at state-owned entities. Term of reference 1.4, Chair, deals with the unlawful award of tenders to benefit the Gupta family or any other family, individual or corporate entity. This evidence will be led in the coming months. State-owned entities such as Eskom, Transnet, Denel, South African Airways, SABC, and others. So, Chair, the evidence that will be given tranches specific to particular state-owned entities. We will begin with Eskom in the coming weeks. But that evidence won't be limited to state-owned entities, and that will emerge when that evidence is led over the coming weeks and months. We have dealt also with term of reference 1.6, which deals with the award through irregularities, undue enrichment, corruption, and undue influence of contracts, mining licenses, government advertising in the New Age newspaper, and other government services. And we refer there, for example, to the evidence given concerning the Government Communication Information Service and the New Age newspaper, about which there's been extensive evidence and which has become the matter of some controversy, and those issues will be dealt with, as well as the expanded issues, mining licenses and the like, under term of reference 1.6. We have dealt comprehensively with term of reference 1.7, Chair. That's the closure of the Gupta bank accounts by the banks. We've also dealt comprehensively with term of reference 1.8. That is the appointment without due process of advisors to the then Minister Des van Rooyen. We have dealt with the circumstances in which that took place.
I guess when you say evidence relating to the appointment of advisors in the Ministry of Finance has been dealt with comprehensively, you don't want it to be understood to mean evidence in that regard has been completed. Because there's certainly
dealt with substantially.
So there are still witnesses to be called.
Again, both in relation to term of reference 1.7 and 1.8, there may be further evidence. As was stated in the opening address, Chair, term of reference 1.5 and 1.9 deal with the nature and extent of fraud and corruption at an analytical level, and it will be dealt with on that basis rather than the basis of cataloguing and detailing each and every act of corruption. So, having placed today in its historical context, DC Chair, the focus of evidence in respect of 2019 is as follows. Firstly, to complete the categories of evidence to which I've just referred that was led in 2018. Secondly, to deal comprehensively with state capture, corruption and fraud in the various state-owned entities and government departments. Thirdly, to deal at a level somewhat different from previous evidence with terms of reference 1.5 and 1.9, the nature and extent of corruption on the one hand in Schedule 2 entities, principally state-owned entities, and on the other hand, national government, provincial government, and municipal government. And then to deal with remaining matters within our terms of reference. For the immediate future, however, that is the evidence that will be led in the first part of 2019, there are two topics or categories of evidence that bear mention. You will recall, Chair, that term of reference 1.4 talks of the unlawful award of tenders to benefit the Gupta family, but expressly mentioned in terms of reference 1.4 are references to other families, individuals or corporate entities. And the evidence of the next 2 weeks will focus here. Secondly, law enforcement agencies. Chair, there will be evidence from and concerning law enforcement agencies to follow the next 2 weeks. The view of the legal team is that central to the environment fraud may take place, and central to its detection and prosecution, and ultimately its prevention, is the role and conduct of law enforcement agencies. And a considerable tranche of evidence in the next 2 months will deal with these issues. Having said that, Chair, it's perhaps convenient then to deal with the evidence that will be led today and in the days that follow. Term of reference 1.1, if I may refer to term of reference 1.1, reads, whether and to what extent and by whom attempts were made through any form of inducement or for any gain whatsoever nature to influence members of the National Executive, including deputy ministers, office bearers and or functionaries employed by or office bearers of any state institution or organ of state or directors of the boards of SOEs. So that part of term of reference 1.1 is broad. It's any attempt and by whom such attempts were made through any form of inducement or for gain. That is the focus of the evidence that will be led today. 1.4 of our terms of reference talks about the unlawful awarding of tenders by state-owned entities or any organ of state to benefit the Gupta family or any other family, individual or corporate entity. And the evidence of this week will deal with other family, individual or corporate entity other than the Guptas.
Yeah, I guess might be important to emphasize that last part of 1.4. Any other family, individual or corporate entity doing business with government or any organ of state.
Yes.
Yeah.
So we will lead evidence, Chair, over the next few days with your leave that deals with the conduct of other family, individual or corporate entity, as quoted there, doing business with government or any organ of state. Then I've already referred to 1.5 and 1.9. The evidence to follow in the next few days will shed some light, if that evidence is accepted by you ultimately, Chair, on the nature and extent of corruption, both in relation to public entities and in relation to state entities. So, what is immediately apparent from the terms of reference, Chair, is that our terms of reference contemplate an unlimited families, entities or individuals who could be authors or beneficiaries of state capture, corruption and fraud. The witness about to take the stand is Angelo Agrizzi, a former employee of Basasa, as it was previously known. He is what may be loosely termed a whistleblower, and I don't intend to use that term, Chair, in any definitive or statutory sense, specifically disavow such use of the term. For present purposes at least, we may regard Mr. Agrizzi or witnesses in positions similar to Mr. Agrizzi as a person who on his own version participated in or collaborated in unlawful acts of what arguably may constitute state capture, corruption and fraud, and is now willing to disclose those unlawful acts and those of his colleagues. So it's particularly in that sense that the term whistleblower perhaps loosely may be used, but we prefer to look at the particular nature of this particular witness's evidence. He participated in unlawful acts and is willing now to disclose them. So, Mr. Greasy will, with your leave, Chair, testify to corporate and individual conduct over a period of many years, bordering on 20 years. He will testify to conduct involving bribery, fraud, corruption, money laundering, and arguably even on his own version, state capture. If I may refer to a very useful memorandum prepared by the legal team that describes his evidence perhaps more accurately. This witness will make it clear that he has played a significant role in operational matters, including the preparation of documents used by his former employer, Basasa, for the purpose of bidding for contracts and tenders from government departments, agencies and entities, and the payment of monies, cash monies, to those who enabled the successful award of tenders. The primary contracts that were awarded to Basasa were in connection with the provision of catering and security services in various departments of government, including the Department of Correctional Services. The evidence that the witness intends to lead with your leave, Chair, can be characterized at its very least as sensitive, in that the information relates to the disclosure of unlawful conduct, corrupt activities and deceit that implicates public office bearers and individuals who occupied material positions in government entities or corporate entities. His testimony will not be exculpatory, it rather implicates him in the unlawful conduct that he seeks to disclose. For the reasons that I'm about to canvass, Chair, which relates to compliance with the rules and other matters, the fact that Mr. Greasy is scheduled to appear before the Commission has been kept confidential. Not only has his identity not been disclosed, but no person, implicated or otherwise, has been given notice of the intention to call Mr. Greasy as a witness. Now, before dealing specifically with two issues, Chair, which I must deal with before the witness testifies, we must emphasize that we approach the evidence with caution. The evidence could, in theory at least, be entirely fabricated. It could be exaggerated or distorted. It could be motivated by improper motives. Or it could be reliable and true and correct in part, material part, or as a whole. We emphasize, Chair, that we make no prior submissions on the cogency or reliability of the evidence. We make no prior submissions on whether it is comprehensive or not, whether it's all the evidence. We will talk about some of the details in that regard in due course. Ultimately, Chair, it is the responsibility of the Commission, particularly yourself, Chair, to make those decisions in regard to the value of that evidence. But for the present, we are able to say that there is substantial corroborating evidence available and to be presented in the form of video recordings, in the form of transcripts of conversations, audio recordings, documents, and other witnesses to follow. The witness does indeed implicate himself in serious criminal acts. The evidence is not exculpatory. The evidence has been and will continue to be subject to thorough investigation by a team of experienced investigators. And finally, those implicated by this evidence will have a full opportunity to test the evidence and put their versions and contradictory evidence. So the legal team has determined, Chair, that our submission to you is that the evidence should be heard. It is manifestly in the public interest that it should be heard. After all, this is an investigation. It is the duty of the legal team to present, the investigative team to investigate, and with respect to you to hear the product of all such investigation work. Only once all the above processes have been completed. In other words, the evidence has been heard, the corroborating evidence has been heard, investigations have been completed, and all parties have been given an opportunity to test the evidence and put any findings. And this will be after an evaluation of all the evidence before you. But for the present, Chair, two questions arise. The first concerns whether implicated persons should have been given notice of Mr. Agrizzi's testimony before today, because the manner in which this evidence is being treated differs somewhat from the norm established by the rules, and I will deal with that in a minute. The second issue concerns whether the witness's evidence should be heard in camera or not. As to the first question, Chair, you have before you in a file an affidavit of the lead investigator in this particular tranche of evidence, Mr. Frank Dutton. And if I may refer to that affidavit and in brief summary put before you what Mr. Dutton says. On page 1, Mr. Dutton sets out his considerable experience as an investigator. On page 2 of that affidavit, he says that since September 2018, I have met and interviewed Mr. Agrizzi on numerous occasions. He has openly disclosed his personal involvement in the corruption and criminality which he has revealed. He implicates about 38 people, many of whom are persons of stature and influence in alleged corrupt practices, money laundering and tax evasion. This includes bribery of public officials and politicians. He says in paragraph 11 of the affidavit on page 2, investigative steps that our investigation team has taken has independently confirmed the accuracy of several aspects of his allegations. He summarizes the evidence to be given, with your leave, Chair, as follows. Agrizzi alleges that the senior management of a group of companies known as Basasa, senior government employees, politicians and others are and were involved in criminal activities centered on tender fraud and corruption for the past 20 years. The amount of money involved in these illegal activities probably amounts to billions of South African rands. All those involved in these corrupt practices received substantial cash and other gratuities. This is Mr. Dutton's gloss on the investigations. An SIU investigation during 2009 and 10 into Basasa corruption recommended criminal prosecutions of some Basasa management members and government officials. That recommendation was made to the National Prosecuting Authority. There will be allegations that officials of the National Prosecuting Authority were bribed to impede further investigations and prosecution into the Basasa matter. And we know that to date, Chair, 10 years later, no prosecution has in fact taken place. In paragraph 17, and this is pertinent to the reason why no prior notice has been given of this evidence, Dutton turns to the attempt to coerce Agrizzi into silence through payments and through other persuasive methods. But in paragraph 18, Dutton says that the coercion to persuade him not to disclose his knowledge has gradually increased to threats against him and his family. He regards these threats as real and credible. And whilst the threats do not shake him, says Dutton, he recognizes and accepts that his life is endangered. Importantly, in paragraph 19, Chair, Greasy says the following, through Mr. Dutton. Greasy expresses fear that it would endanger him if advanced warning is given of his intention to testify before the Commission. He believes that those he is going to implicate in serious criminal conduct will harm him in an effort to silence him. Once his evidence is in the public domain, the threat against him will be considerably reduced as the motivation to silence him will fall away. He believes emphatically, it should read, that public knowledge will ultimately provide him with the best protection possible. Until his evidence is in the public domain, however, the threat to his person is real and substantial. Dutton continues in paragraph 20 to say, Greasy has therefore requested that advance notice of his testimony to the Commission be withheld and that implicated parties be informed of this fact only during or after his testimony. And I can state, Chair, that at the present time, implicated parties are in fact being informed telephonically of the evidence to be given with your leave today. In paragraph 21, Mr. Dutton says the investigation team has sought to obtain as much corroboration as possible to support or refute Mr. Agrizzi's allegations. And the preliminary investigative steps taken follow. So, for example, Mr. Agrizzi will say in his evidence that at a stage he was shown what ought to be confidential NPA files in relation to the Basasa investigation. He was shown those on the 6th floor of the Sheraton Hotel in Pretoria, and he took opportunity to photograph those files. Those are in the bundle to be handed up to you, Chair. Interestingly, the photographs show a carpet pattern, and the investigators have confirmed that that is indeed the carpet pattern of the Sheraton Hotel. They've also established, Chair, that the person who handed over or who disclosed this documentation to him and others from Bosasa in 23 September 2015 by Ms. Dudu Miyeni coincided with a residence of Ms. Miyeni in the same hotel during September 2015, and in particular on the same day. There is a video clip which will be played today, or if we don't get there today, tomorrow or the next day, where Mr. Watson of Bosasa is seen counting out cash money, and the transcript of that video has been included in the bundle. Cash money of 110 Rand per month, for example, to a person called Patrick, who's been identified as Patrick Gillingham.
110,000 or 110 Rand?
110,000 Rand.
Yeah.
Per month. Then, Chair, there are various other references to audio recordings, and in particular, may I refer to paragraph 26, where reference is made to an audio recording of persons talking about Mr. Greasy, where they indicate that they are prepared to cause him harm or have third parties cause him harm. A person in one audio recording purported to be a Mr. Gumedi, a director of Bosasa, and he can be heard telling people that Mr. Greasy must watch his back because a prisoner could easily be released from Westville prison, kill someone, and then be returned to the prison and have a solid alibi for the killing. That evidence has been investigated and it will be before you. And then the investigators say, and this will obviously be tested by the investigation team, tested by yourself, Chair, before you evaluate the evidence, but the statement is made in paragraph 28 by Mr. Dutton. A close inspection of the documents, video recording, audio recordings, and other evidence produced by Mr. Greasy do not disclose any alterations, tampering, falsifications, or other signs which could challenge the integrity or credibility of the supporting evidence. Chair, we do not place this before you at this stage in any definitive sense as a conclusion that the legal team has reached or as a conclusion that you should reach, Chair. It is merely the basis upon which it was determined, and it is with respect submitted responsibly determined not to give prior notice of the fact that Mr. Agrizzi was giving evidence. All those conclusions, all the evidence referred to in Mr. Dutton's affidavit will be tested. Then in paragraph 31 and following, detail is given of the nature of the threats and coercion exercised. And without going into too much detail, Chair, from paragraph 31 to 70, these threats over a period of time, particularly in the last few months, has been catalogued. I may just refer you to the awareness of Mr. Greasy of threats against other persons in positions similar to him, of his belief that he has no doubt that illegal methods could be used to silence him. In paragraph 38, he states that he has received frequent anonymous calls in which the unknown caller would hang up on answering, would badmouth him, or threaten him with harm or death. There is direct evidence of the following being said by an official of Bosasa And I quote, "Tell Agrizzi we have been patient and he needs to be careful. We don't want another funeral shortly." That conversation is detailed further in paragraph 40. I've alluded to it already. And that recording has been transcribed and it is in the possession of the Commission. The allegation is made in relation to a warning given to Mr. Greasy telephonically that Watson could make people disappear. And the allegation is made in paragraph 46 that from December 2017 to March 2018, Agrizzi received a series of threatening and other strange telephone calls. There's evidence on page 10, paragraphs 49, paragraph 50 to 56 of an interaction with a private security person hired by BASASA to protect its interests, involving, amongst others, Mighty Schultz, who is well known in circles in Johannesburg and South Africa. The threats have been reported to the Hawks, and this report was made in September 2018. And the affidavit is attached. I will refer to it briefly, both to the affidavit of Mr. Dutton and to the confirmatory affidavit of Mr. Agrizzi. At a time when Mr. Agrizzi was preparing a statement through his erstwhile lawyer for presentation to the Commission, Mr. Agrizzi reported that as from 20 December last year, 2018, he again started receiving anonymous, silent and threatening phone calls, and these calls are still persistently received by him. He has been warned that his safety is in danger by a member of the press who has spoken to Mr. Agrizzi on several occasions and appears to have knowledge of circumstances surrounding the investigation and circumstances surrounding the State Captcha Commission, its investigation, and circumstances surrounding the SASA. This warning is summarized, or not summarized, is highlighted in paragraph 64.6, where the reporter said to, or the journalist said to Mr. Agrizzi, "Just be careful. I think people are watching you quite closely, listening to what you say. So please be careful. I know you're always careful, but be extra, extra careful." Following this call, the Commission provided protection, and that protection continues. So the conclusion reached by Mr. Dutton after all these investigations, reports and factual investigations appears at paragraph 67. "I had already concluded in early December 2018 that there is a credible and real threat to Agrizzi's safety, especially if it became known that he was going to whistleblow and implicate numerous high-profile public persons, BASASA management and others in, amongst other things, corruption, money laundering and tax evasion. There would, in my view, be a real risk of attempts to silence him and to deny the Commission the opportunity of hearing his testimony." So in short, given firstly the nature of the evidence to be led, the people to be implicated, the history of the matters in relation to which testimony will be given, the real threats to Mr. Agrizzi, and the evidence corroborating such, one can be left with little doubt that, in fact, there is a material basis upon which the apprehension has arisen. I'm not going to take it any further, but perhaps to say that this matter was reported to the Hawks. The affidavits are attached. There is a confirmatory affidavit in the second part of the bundle from Mr. Agrizzi himself. where he reaches the following conclusion, and he himself again attaches the affidavit in which the threats are catalogued. So having said that, Chair, we conclude as a legal team in our submissions before you on this particular point that given the evidence that Mr. Agrizzi is likely to give, there's every basis to conclude that there's a motive, at least, to prevent him giving evidence. That attempts have been made to persuade him not to give evidence, and that there's real evidence that some or many of those attempts constitute real threats to him. So the submission we make to you in summary then, Chair, is that there is a manifest public interest that had to be respected in preserving the evidence, in preserving and ensuring the safety of the witness. There's also the public interest in making clear to the public out there that the safety and integrity of persons in positions similar to Mr. Greasy should feel perhaps not comfortable, but at least reasonably secure in coming forward to the Commission to give testimony. Those interests we submit outweigh the interests of implicated parties, and those are real interests. They are interests of fairness, which we do not wish to minimize, but we say they are outweighed by the interests we have said, and those are interests in receiving prior notice. The interest is simply an interest in receiving prior notice before the evidence is given. Their rights are not removed. They are merely delayed to a point where the evidence is actually given. They have rights in terms of Rule 3.5 to approach you for an order to cure any prejudice that they may have been suffered, and each implicated party will be notified of those rights. So, Chair, I will ask for the particular relief that we seek as a legal team in due course, but just to raise a second issue. The second issue that arises is whether, in the light of the rights of various implicated parties, particularly the rights of reputation, is whether the evidence of the witness should be given in camera. That is, in a sense, related to the first issue. That issue has been carefully considered by the legal team. I have the benefit of a very thoroughly researched memorandum prepared by the legal team under the direction of Advocate Kabashi, and its conclusion, if I may just refer you to that conclusion, is that there appears to be no valid basis for making an application for an in-camera hearing of evidence that is in large part already in the public domain. One must recall that there have been press reports in relation to this evidence in the public domain. The issues that we have considered, as I have said, weighing up the public interest, the duties of the Commission, its transparent nature, the rights of the public to know what is happening in the evidence to be given, as against the right to prior notice. The right to defend, the right to cross-examine, the right to put up contrary versions is merely delayed. It's not removed.
The right to apply for leave to cross-examine.
Yes, Chair, of course. And it's not I must correct myself there, and I've from time to time been corrected. I might have a slightly different emphasis in relation to my own views, but they must concede to the rules and to what you have just said. There's no right to cross-examine. It is a right to apply for leave to cross-examine under your direction, Chair. So we ask that the witness be called, subject to the understanding that implicated parties will now be followed and that will now be informed and the procedures and the rules set in motion, and we ask that that evidence be given in open forum.
I understand that the witness himself is quite happy that he gives evidence in the open. Is that correct?
Yes, it is in fact his wish that that occur.
Yes. No, thank you very much. I think that in relation to the decision of the legal team not to give prior written notice as contemplated in the rules to implicated persons and not to furnish implicated persons with this witness statement. What you have done is to put before me affidavits that seek to explain why that decision was taken. On the face of it, it appears to me that subject to whatever any implicated person may wish to say or may say in due course, because I will leave that door open, it seems to me that prima facie there were good reasons for doing so. But I think I should not make any decision, final decision in regard to whether there were good reasons or not, subject to what you may say, but allow the evidence to proceed and we see whether when implicated persons have been served or finished with the statement and all documents, including this affidavit, whether they want to make an issue of that. That's my thinking.
Yes, Chair.
Is that in order? Would that be in order?
Implicated parties have the right, in terms of Rule 3.5, to do precisely what you have intimated, Chair, and perhaps it's apposite not to make any final decision, only a provisional decision at this stage, to allow the evidence to be heard, but any final decision in relation to prior notice once they have been heard. Yeah. Indeed.
So therefore, I will allow the evidence to be led and to be led in the open. And as Mr. Pretorius has indicated, all implicated persons' rights in terms of the rules of this commission and the regulations, other than the right to be informed in advance of the giving of evidence by witness, all those other rights will be complied, will be respected, and the requirements of the rules will be complied with. This means that Mr. Agrizzi's statement and all relevant documents will be made available to them, and then they have to put up their versions as well and basically follow the rules. I just emphasize what I have said before, what we keep on saying. All implicated persons implicated by witnesses who come before this commission will be dealt with fairly. If they want to give evidence, they will be given that opportunity. If they apply for leave to cross-examine, their application will be considered properly, and their versions will be given due consideration. So I will take this opportunity to say to the witness who was about to give evidence that whether or not his evidence will be found in the end to be truthful or not is a decision that I will take at some stage in the future. But I do want to take this opportunity at this stage to thank him for voluntarily coming up and deciding to come and testify. We thank him for that. We encourage more people who know activities that happened in which they may themselves have taken part, on which they know that other people took part, which relate to corruption, bribery, state capture, to come forward and share that information with us and therefore with the nation on this very important issue, because the entire nation wants to know what happened, who did what, with whom, that has led to where the country is now. So I thank Mr. Agrizzi for coming forward voluntarily to share his knowledge with the commission and to give evidence. And as I say, whether or not his evidence is true, that is something that will be decided later, but I thank him for coming forward. Thank you.
Thank you, Chair. As stated, the name of the witness is Angelo Agrizzi. His full names will be given to your registrar to be sworn in.
Yes, administer the oath, registrar.
Please state your full names for the record.
My full names are Angelo Agrizzi.
Do you have any objection with taking the prescribed oath?
I do not.
Do you consider the oath to be binding on your conscience?
I do.
Do you swear that the evidence you will give shall be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you. You may proceed, Mr. Pretorius.
Thank you, Chair. Chair, you have before you two bundles. They will be Exhibit S1 and S2. If I may take you to the cover page of bundle S1.
The one I have here is written on the spine, bundle 01. Is that the one you say should be S1?
Yes.
So, okay, we say exhibit.
You will see volume 1 of 2
Yes.
on it, hopefully,
Yes.
on the binder.
So, exhibit S1 will be bundle 01. Is that right?
Chair, I'll explain that to you in a moment, but does it have beneath it volume 1 of 2?
Yes.
Yes.
Is that so? Is that marking
That's
correct?
S1,
Okay. All right.
and the other one then will be S2.
Then there is the lever arch file marked on the spine bundle 01, and then it says volume 2 of 2. That one will be exhibit S2. Thank you.
And if I may just explain, Chair, to avoid any confusion, the reference to bundle 01 is the reference to the first bundle which has been given to you, Chair. I have bundle 02 and everybody else has bundles and sequence number. That is so, it's a device being instituted by the investigators to ensure that every person who receives a bundle can be accountable for having received a particular file with particular documents in it. And that is why you have received bundle 01, I have bundle 02, and each person who receives a bundle has a particular numbered bundle. The reason for this has been to attempt to tighten up on the security within the Commission, and you will have noticed, Chair, that this is one of the rare occasions on which the press have not published a statement before the witness gives evidence. So it seems that the security measures that have been implemented have, at least in this case, been marginally successful.
Yes. So what I have here, the two bundles are both marked bundle 01.
Yes.
And then the one is further, or is written bundle 01. The one is further written volume 1 of 2. And the other is written volume 2 of 2.
Yes, Chair.
So the 01 applies to both bundles.
Yes, Chair.
Okay.
And then, Chair, if I may just ask you, by way of preliminaries, to turn to the second divider in bundle S1. And you will see there a comprehensive index of several pages detailing and indexing the various annexures which will appear in the bundle.
Yes.
On the last page of that index, you will see that there are a number of exhibits. You do not yet have in the bundles the original exhibits. Those will be shown or played in due course. But the transcript of Exhibit 1, that is the video recording which will be played when we get there, has been handed to your registrar, and you have it in a brown envelope.
Yeah.
Those are not obviously part of the paginated bundle.
Yes. You made a reference just now to Exhibit 1. Where is the reference to Exhibit 1? I just want to make sure that as we talk about the evidence in this bundle, we don't cause confusion for the reader of the transcripts in months to come when we refer to Exhibit 1, whether that's a reference to the original Exhibit 1 that we had at the beginning. So we just need to be careful.
I understand that.
Yeah.
Chair, perhaps the exhibit should be numbered Exhibit S1, Exhibit S2, and following.
Yes.
And we'll amend that page accordingly.
Yeah.
And we will refer to them. I trust I will remember, and if not, you will no doubt call me to order, Chair.
Yeah, so that can be done, and if need be, during the lunch break or in the afternoon after the adjournment, somebody can just make sure we have the same numbering of those exhibits.
Thank you, Chair.
Thank you.
If I may then proceed.
You may proceed.
Thank you. Mr. Greasy, you have the bundles before you?
Yes, I do. I just want to say good morning, Chair. Thank you for having me. And good morning, Mr. Pretorius.
Good morning, Mr.
Good morning, Mr. Agrizzi.
Chair, perhaps there's something else I should mention. Because of the basis upon which the pages were numbered in the bundle, you will see for example, page 1, the first page of the affidavit of Mr. Greasy, AA 001. For all practical purposes, I'm not sure, I don't understand these things always, Chair. I don't know why the AA is there, but it can be ignored. We will refer just to the numbered pages. Thank you.
Okay, thank you.
Mr. Agrizzi, the affidavit appears in the first bundle you have.
So I'm sorry, before you say that, so in other words, if the transcript of today's evidence and or the transcript relating to Mr. Agrizzi's evidence were to later on show that we are talking about page 1 or page 3 of his affidavit, and the reader goes there and finds page AA001 or AA003, they must understand we are not using the AA and 00, we are just using the actual number.
We are just going to refer to numbers,
Yeah.
not letters, in relation to any page in the bundle.
Yeah, okay.
Mr. Griese, the affidavit which has been placed in the bundle appears at page 1 to 106.
Correct.
Would you look at page 106, please?
Yes.
Whose signature is that appears under the word, over the words Angelo Greasy?
It's my signature.
And the initials on the individual pages, are those yours?
Correct.
You apparently, from the information on page 106, attested to this affidavit yesterday.
I have.
Yes. As far as you know, and subject to any correction that might be brought about in the affidavit, are the contents of this affidavit true and correct?
They are.
We could go then to page 1 of your affidavit. I will ask you to deal with the matters as they appear in sequence in your affidavit, but in your own words. Right? I might from time to time, with the leave of the chair, lead you. You are a businessman and you live in Johannesburg.
Correct.
And you were born in Germiston, Gauteng,
That's correct.
and you're a South African citizen.
Yes, I am.
Are you married with children?
Yes, I have.
You've heard, and it's already been clearly stated to the chair, both by myself on behalf of the legal team and on affidavit, that this statement incriminates you in respect of potentially serious offences.
I'm well aware of that.
Have you reported these acts as required by the Prevention and Combating of Corrupt Activities Act, particularly Section 34?
I have not.
Has any influence or coercion been exercised on you in relation to the giving of this evidence?
Not at all.
Have you been offered any incentive or reward for giving this evidence?
Nothing whatsoever.
In paragraph 3 of your affidavit, and by way of introduction at this stage, we will deal with it in more detail later, you record that during your employment at Bosasa, you were exposed to unlawful acts over a long period of time. Could you just expand on that, please?
I started my employment at Bosasa Operations many years ago in 2009, to be precise, and I left Bosasa on the 15th of December 2016, and I was exposed to numerous corrupt activities. I did not, unfortunately, report them at that stage.
1 second before you proceed, Mr. Pretorius. Earlier on, before we had a witness using that mic, I checked whether everybody could hear. I now want to check that they can hear the witness clearly. Right at the back. Yes. Can you all hear the witness? The one says yes, another one shakes the head. It looks like some cannot hear.
Can you hear me now?
How is that? I think they can hear. Maybe you can raise your voice, and the technical people can also do whatever they might be able to do to make sure that everybody can hear. Thank you very much. Let's proceed.
And perhaps the microphone should be closer to you, if you can manage that.
Yeah, it not be too close. Yeah, but I think if you raise your voice, it should.
Is that much better?
Very much better. Thank you.
Thank you, Chair.
Yeah.
Mr. Greasy, given the period of time over which you will record or attempt to recall and testify to, has it been possible for you to recall everything? And I refer particularly in the time that you've taken to prepare the statement.
It has not been possible to recall absolutely. It's just too voluminous.
Right, and so should cross-examination or questioning here or investigation give rise to any further channel of investigation or channel of questioning or provision of further evidence, are you willing to cooperate in providing that?
As previously I said in my statement, I'm more than willing to assist.
And if necessary, your affidavit can be supplemented.
Most definitely, Chair.
Now, I recall you saying in answer to my question as to the period of your involvement with BSASA, you mentioned the date 2009. Is that correct?
No, I commenced employment in 1999.
Right. And you terminated your employment when?
2016, 2017. The reason why there's two different dates is because there was a process of negotiation until 2017.
So
but
we'll
my last date of work at the business was 2016, 15th of December.
And it is in that period of almost 20 years that your involvement in these activities about which you're going to testify took place.
Correct.
And it is in respect of that period of time that you say you could not possibly remember each and every incident.
That is correct.
That might be relevant to the Commission's work.
That is correct, Chair.
So it follows from that there is probably a need for ongoing interaction, and you're willing to participate in that.
Most definitely.
And then in paragraph 4, again by way of introduction, and we'll deal with it later, you give some explanation of why you have decided to cooperate with, firstly, the Commission, and secondly, law enforcement agencies. Could you tell the Chair briefly and by way of introduction of the background to your decision, perhaps not the background at this stage to your decision, but why you've made this decision?
I'd become blunt in understanding what was happening at this stage, and I'd become very accepting. And unfortunately, it happens to a lot of people. And my urge as well is for people out there, especially in BSASA, to start coming forward as well. So I was blunt, I'd kept quiet, and I should have exposed the unlawful activities from day one.
It will be put to you from time to time during your evidence, and no doubt it will be put to you in cross-examination in due course, why you took so long to come forward.
I understand that.
Briefly, the answer to that question?
The answer to that question is very similar to being involved in a cult, Chair, that you become so engrossed with what is happening, and you actually start believing what is happening is right. And that's why it took so long. I had a near-death experience where I was admitted into hospital and I had a tumor on my heart. I was in a coma. And when I came out of the coma, myself and my family had made a conscious decision that we would clean up where we had made mistakes before.
At paragraph 6, Mr. We'll return to these issues during the course of your evidence. But for the moment, can we move on then to paragraph 6 of your statement? You schooled in Germiston and you matriculated in 1985, is that correct?
That's correct.
And you were employed part-time during your school years to fund your studies?
From the age of 14, that is correct.
Your training at Wits Hotel School, when did that occur?
In 1986, I received my first year. I did my first year.
Right. And did you continue with these studies?
I couldn't afford to. My parents couldn't afford to. I couldn't work and study at the same time. It was far too difficult.
What did you then do?
I then worked for a restaurant where I'd been working already at Jordan's. In Germiston, I worked there full time. Do you want me to carry on, Chair?
Well, just carry on from 1989 then.
I then continued to work. I tried to study and develop myself, understand the industry in which I had found a job. And I was then employed by a company called Hospitality Food Services, where I was a project manager for an industrial catering company. I then left hospitality. I honestly wanted to make a difference in the mining industry. So I joined Gencore Mining. And I worked for one of my mentors there who trained me and taught me about large-scale facilities, high-density catering services. Then in 1993, I accepted a position that was offered to me as a project manager with a company called Supervision Food Services at Western Platinum Mines in Marikana, Rustenburg. So I relocated with my family. I was then promoted to run Nissan Rosalind's facilities management in 1994, and I again relocated my family. In 1997, I applied for a position with a company called Grantham Integrated Food Services, and I was stationed at Oryx Mine in Valcom for a period of 8 months.
Would you just pause there for a moment? We will continue in due course with your employment history and particularly how you became involved with catering at large institutions. But if I may interrupt you, my apologies. Chair, I've had a request from the technical team to adjourn for 10 minutes to deal with some technical issues. I'm not sure what they are, but that is the request. And it's also time for the short adjournment.
Yes, no, that's fine. We will take the tea adjournment now, so it will coincide with that. And we will resume at 25 to 12. We adjourn.
All right, the first session of 2019 of the inquiry into state capture is set to be explosive. Surprises already. We have the likes of Angelo Agrizzi, the former COO of Bosasa, testifying currently.
Hit the ground running there. Let's take a break. We'll be back in a moment.
2. Mic check 1 2 1. Yeah, in general. Okay, 1 2 3 1 2 3. Yeah, 1 2 3. In general. 1 2 3. Yeah, I'm speaking on the Benkurma Guya Manch. Okay, Zanet. Ngara you wanna your desk. Make sure it's only one channel on. La amanye angabi on. I'm sorry, guy. Get it. You again. Can you check it? Jan. Okay. Can you check out the other side? 1 2 3. Yang tournament. Yang tournament in Jan. Cut two times extender. It about defocused. Cut two times. Cut two.
the light of the failure to, feed the public broadcaster, whether it's necessary to repeat essential features of what the witness has already said, or whether it's not really necessary. I don't know if you have thought about it.
Given that the matters are introductory only, and given that the feed wasn't entirely interrupted, but only
Yes.
partially,
Yes.
perhaps that can be
Go ahead,
checked,
yeah.
and once it has been checked, we
Yeah.
can decide what to do
Okay.
at a later stage.
Okay.
Thank you.
Okay, you may proceed.
Thank you. Mr. Griese, you had said to the chair that in 1997 you applied for a position at Grantham Integrated Food Service and you were stationed at Oryx Mine. You gave that evidence.
Correct, it's in my statement.
And how long were you there for?
8 months.
And after that, where did you go?
I was promoted to take over various other operations like Impala Platinum Mines.
And in 1998, your statement continues in relation to your employment. What happened?
In 1998, we were in the process of listing Grantham Integrated Foods into Malope, and I was asked to take over the inland region in its entirety.
And did your wife work with you?
Yes.
In what capacity?
She handled my administrative work as a PA.
Did Grantham Integrated Food Service then become Malope Foods?
Correct.
Was it absorbed into Malope Foods?
Malope Foods, the reason why Malope Foods was listed was because of the Grantham Integrated Foods.
When employed by Malope Foods then, were you tasked with the oversight of a catering contract at the Scott Hostel in Klerksdorp?
Correct.
Who did you work with there?
I worked very closely.
That information.
He told me about a company called Diambu Operations and a person called Gavin Watson. He told me that Diambu was exploring the possibility of replacing Malope at that stage as the caterer at Scott Hostel. So in order to gain workers' support, because they utilized the facility, he would provide them T-shirts and caps branded Diambu to the workforce. And they would then obviously protest against the current catering contractors being Malope, and to support Diambu in obtaining the catering contract. That was the modus operandi.
And did you become aware of the fact that Diambu had an interest in contracts at other mine hostels?
Yes, I did.
What happened then in early 1999 in relation to your relationship with, or your potential relationship at that stage with Diambu and Mr. Gavin Watson?
In 1999, I was opening up a place of safety called Narina Place of Safety in Port Elizabeth. And I was on my way back from Port Elizabeth, and I was at the airport. And I heard a gentleman speaking Xhosa, but I also heard some distinct words, Diambu chair, mining and catering. I then did my research. We didn't have Google as good as it is now, but I did my research and I found it was Gavin Watson, who Donnie Liebenberger told me about.
Did you follow up?
The country was in Diambu itself that could take growth and go into the facilities management sector and make it grow phenomenally.
Did you then speak to Gavin Watson?
Well, not at first. At first, what happened was I found the contact details for Diambu. I eventually made contact with a gentleman by the name of David Sadie. David Sadie was very impressed with me, apparently, and he took me to Danny Mansell, who was the...
You indicate whereabout in the statement you are as you lead him.
I will do, Chair, my apologies. We're at paragraph 6.16 of your statement, 616. You told the Chair that there was an agreement, to your knowledge, to be signed the following day. The parties to this agreement would be Malope on the one hand, and who on the other?
The agreement was with Goldfields Limited, the union, There was a tripartite agreement between Goldfields, the union, and at that stage, Malope.
And you told Gavin Watson about that?
Yes.
And the union being what union?
It was the National Union of Mine Workers.
Thank you.
What was Gavin Watson's response?
He was very flustered. And he asked me to accompany with Dr. Jürgen Smith on the Monday, I think it was the 8th of May, to actually go there and to ask them not to sign the agreement, but to give Diambu an opportunity to put in a proposal as well.
All right. Firstly, who is Dr. Jürgen Smith, or who was he?
Dr. Jürgen Smith was one of the owners of the previous company before it became Diambu of Meritum, together with Fani van Sale, and Dr. Jürgen Smith was a quasi-mentor to me as well.
He is now deceased, I understand.
Unfortunately, yes.
Well, I'm sorry, Mr. Pretorius, I may have missed this. This agreement that was about to be signed between Malope and the company and the union, was it for the provision of catering services, or what was it for?
It was for the provision of catering services.
And it may be that Mr. Pretorius is still too, and I'm happy to let him deal with it in due course. It just seems odd, the inclusion of the union seems odd in an agreement such as that. Is there something you want to mention about that?
I can mention it, Chair.
Would you do
yes,
so?
Just say
Please.
Well, at the end of the day, and I remember this when I worked at Winkelhoek Mine, our job is to feed or cater for.
To be given a car?
Yes, I was.
And at Malope, was that part of your terms and conditions?
18 of your statement.
I then proceeded to the offices of Malope, and I resigned, and I handed a resignation letter to Mr. Greg Laken Allen.
His name occurs later in your statement.
Yes, it does.
Right, so when did you start employment with Diambu, and what date?
Well, I actually started on the 10th of May, 1999.
Right, did you then, as foreshadowed in paragraph 6.16 of your statement, visit Leeudoring Mine?
Yes, I did.
And is that the mine at which this contract was about to be signed between Malope and Goldfields?
Correct.
Right.
Well, in terms of your resignation from Malope, were you required in terms of your terms of employment to give any notice of resignation, and if so, did you give it?
I did tender notice period, which I explained
Yes.
to Mr. Watson.
Yes.
But they decided in those positions at that level, they normally let you go straight away.
Okay.
Did you accompany Dr. Jürgen Smith to Leeudoring Mine?
Yes, I did.
Did you then deal with the issue at hand, and that's the imminent signature of the agreement between Goldfields and Malope?
No, I did not.
Would you look at paragraph 6.19 of your statement? You say there, I accompanied Dr. Jürgen Smith to Leeudoring Mine and convinced them not to sign the agreement with Malope.
Correct.
So you did?
I did not let them sign the agreement, yes.
Oh, I see. So you did deal with the issue, and you took steps to persuade the personnel at Leeudoring, Goldfields Mine, not to sign the agreement.
Correct.
What motivation did you give as to not sign? Because I assume that in your capacity in which you were employed at Malope, you may have taken the view that Malope should get it. So what did you say to them that convinced them not to continue and sign the agreement?
Chair, I was very frank with them. I honestly believed I'd find a better company with better services at a better price. So I wait a month or so, let us prove to you that we can provide a better product.
Thank you.
Let's move then to paragraph 6.20 of your statement, Mr. Greasy.
Yes.
Your initial position when you were employed by Diambu, I presume it is.
Off me, it appeared to me. That is right.
So which is correct, 98 or 1999? I'm not sure it makes a
19
tremendous amount of difference. But
1999 is the correct date.
1999.
Is what is wrong just the year?
Yes, Chair, I'm sorry about that.
Oh, okay.
And if you go back to paragraph 6.14, should that date also then be 1999?
Correct.
Okay, so those two amendments should be made to your statement.
Will do.
The one is 6.18, the other one?
6.1.
Manager, or what was the position that you were occupying called, or was there no particular name given?
Jack of all trades would have been the correct name, Chair. With all due respect, there was no name given. I was involved with everything.
And business cards, if you had any, what did they say you were?
Marketing
Marketing manager?
coordinator.
Coordinator. Oh, okay, thank you. I just wanted to make sure that we know exactly what your position was called. Thank you. You may proceed, Mr. Pretorius.
So just by way of summary, on your initial employment by what was then Diambu, you were employed in a marketing position, as you say in paragraph 6.20.
Correct.
You say that within a year, your responsibilities had broadened.
Correct.
And you were responsible for operations, amongst other things.
Correct.
And what was your position within that year in relation to the management and submission of tenders?
I would be integrally involved in the management and submission of all tenders.
Now, in paragraph 6.25, you speak about prayer meetings, and I'm not going to prevent you from giving this evidence, but perhaps you should tell the Chair why you were referring to these practices at Bosasa.
Chair, if I may, I'm a Christian, and when I joined Bosasa, one of the predominant reasons why I made that decision because I believed it was God sent. However, every morning I was told there was a prayer meeting in some mornings, and I'd got to know a few people, and they would attend. And between 12 or 15 people would attend every morning, and this was led by Gavin Watson. He would lead the prayer meetings, and I was impressed. He would share a verse out of the Bible, and it would be discussed, but everybody would have to pray out aloud. That was the rule. I, as Gavin Watson's right-hand man, everybody looked to me. Did I attend the prayer meetings? So I was compelled to attend the prayer meetings. During 1999, they extended the prayer meetings. Another employee, a youngster, who I had kind of grown fond of and taken under my wing to mentor, Leon van Tonde, was at these prayer meetings, said that these prayer meetings should happen actually every day if we want God's blessing over the company.
Anything further before your next question?
Say what you wish to say about that, and then I will ask you a question about this evidence.
So we started every morning, and I believe, I really do, that it was sincere. So from 6:30 to 8 it would continue. But it became a kind of a cult. They would invite prophets, not much dissimilar to what you see on TV. They would invite certain pastors from occasion to occasion. They would lead these prayer meetings. And then they would have all-night prayer meetings as well. But quite simply, it was a mockery. And I'd compromised by even being part of it. But you see, Gavin Watson was a very charismatic leader, and he had a lot of influence over all his employees. I think that answers my question.
All right. That answers the question I was about to ask you in relation to Gavin Watson's strength as a leader and his degree of influence over his employees, but you've answered that question. I want to deal briefly, merely to introduce the document with the information contained in Annexure A to your statement. And that appears at page 107 of Bundle S1. If you would go to page 108, please. Institutes.
Thank you.
Just to fast forward, because we're dealing at the moment principally with your employment history, what actually occurred during the course of your employment we'll deal with in much more detail in due course. But what happened in August 2016?
I don't know if you want me to refer to my statement, Chair, or if
Paragraph
you want me
6.27.
Well, you can speak without referring to the statement if your recollection is quite fine, but if you do need to refer to the statement, feel free to do so, because this is a long time ago. So, yeah.
Well, quite simply, Chair, thank you. In 2016 August, I resigned.
The purpose of introducing that at this stage is merely to introduce two agreements that were entered into that appear as Annexure B and Annexure C. Now, the circumstances in which these agreements were concluded and the relevant facts in that regard will be dealt with in detail at the end of your evidence. But for the moment, would you tell the Chair what is Annexure B and what is Annexure C, the two agreements you refer to in paragraph 6.28 and 6.29?
On about the 25th of August, I entered into a settlement agreement with Persuasive Operations, Concilium Business Consultants, Daniel John Watson, otherwise known as Cheeky Watson, and Gavin Joseph Watson.
Before you go on, Concilium Business Consultants Pty Limited, was that a company which was part of the Persuasive group of companies?
Indirectly, it was part of the Persuasive group, but it was owned actually by Dr. Jürgen Smit.
Yes. Why was this agreement entered into?
Because I'd resigned and they wanted me to come back urgently. Right. They wanted me to be on a fixed term contract for a period of 10 years.
Did you enter into that agreement?
Yes, I did.
After your resignation on 25 August 2016?
That's correct.
You will give evidence in due course about why you resigned in August 2016. That's detailed evidence, and we need to deal with it in its proper context and chronology. But what persuaded you, having resigned, to enter into this agreement called the settlement agreement?
I was promised, Chair, things would change dramatically, and all the points I'd raised previously would be addressed. That is why.
And then what is Annexure C? You deal with it in paragraph 6.29.
Yes. Annexure C is the incorporations of provisions regarding the consultancy agreement, which was entered into on the 18th of March. Basically, it's a settlement agreement to get out of the previous 10-year agreement.
So do I understand you correctly? The agreement which provided for your re-employment after your resignation with Persuasive for a period of 10 years was superseded by another agreement?
Yes.
Which replaced it?
Yes.
And what did, in very brief terms, what did the second agreement provide for?
The second agreement provided for a consultancy with Persuasive at that stage, and it provided to pay me a monthly consultancy fee, which was equated to about a tenth of the previous agreement.
So you say the financial benefit of the second agreement was substantially less than the financial benefits of the first agreement.
If it had been paid in full, yes.
Yes, we'll deal with it in more detail in due course and in its proper context. But your status, having entered into the second agreement, was, as I understand it, you had resigned and that resignation was confirmed.
Yes, that's correct.
And you had resigned your employment.
Yes.
All right. In paragraph 6.30, you deal with the income and other benefits received from your employment at Bosasa and Diambu during the period 1999 to 2016.
I'm sorry, before he answers that, Mr. Pretorius, just for the sake of completeness, in the light of the second agreement, Annexure C, your relationship with Bosasa had become that of a consultant, is that right?
Correct.
Okay, thank you. You may proceed, Mr. Pretorius.
Let's just clarify that, Mr. Greasy. Did that agreement continue in operation?
The
The second
consultancy?
agreement, the
No.
consultancy agreement.
No, it's been cancelled.
Okay. And you'll give evidence as to the circumstances in relation to that.
Most
in due
definitely.
course. Paragraph 6.30 deals with the income and other benefits received by you during the course of your employment at Bosasa in the period 1999 to 2016. Right, and you attach documents which appear to confirm this as Annexure D1 to D22. Before we go into the tables which appear further on in your statement, would you just explain to the Chair what you wish to in paragraph 630.1 and following?
Chair, if I understand the question correctly through Advocate Pretorius, am I to explain why I decided to put in my earnings into a document like this?
No, you in paragraph 630.1, you qualify or explain the tables which follow.
Yes.
And you raise certain facts which are relevant to the tables which follow.
Yes.
Would you just put those before the Chair, please? You can refer to paragraph 631 and following.
Well, the reason I put it in there was because partly in the beginning, my wife, and also the relevant fact is that my wife was actually my personal assistant at Malope. And when I left Malope, because I was in a senior position, she obviously wouldn't be a personal assistant at Malope anymore. So she was dismissed as I joined an opposition company.
And she lost the income from employment.
Yes.
But let's look at paragraph 630.1 for a moment. You say my salary between the period 1990.
Yes, it was.
And that was not a correct or even a false representation.
Not at all.
You say it was not false.
I don't believe it was false.
Explain that, please.
Well, my wife had been working for me, and she had been getting a salary. I'm not sure I understand your question or your line of questioning.
Okay, maybe let me see if I can
Yes.
ask this. The one thing you say in the relevant paragraph is that what was your salary was given, or part of what was your salary or was meant to be your salary was given to you, and another part was given to your wife.
Yes.
Okay. Maybe before we proceed, was your wife employed by Diambo stroke Bosasa when this happened?
She didn't do any work, no.
So she was not employed by Diambo or Bosasa?
No, only on paper.
Yes. Now, in relation to tax,
Yes.
was the salary that would have been represented to the tax authorities as the salary that you were being paid by Jambo, or Busasa, was it only the part that was given to you? In other words, was the part that was given to you reflected as the complete salary, or was it indicated that what you actually received was only part of the salary and the other part was given to your wife? Was that reflected in communication and tax documents with the tax authorities?
I misunderstood the question, I'm sorry. My answer to that is very simple. It was not correct, but it was based on the advice.
So by representing that your salary...
I'm sorry, Mr. Pretorius, he has understood what I think you were asking,
Yes.
and he has answered that question, but I think I would prefer that he answers it directly in terms of the question I've put to him. I put the question now in my own way. Your salary, as represented to the tax authorities, was it the salary that was being given to you only that was represented to the tax authorities as your whole salary? And, or maybe let me stop there. What's the answer to that question?
The answer is yes, it was represented.
As the whole salary?
There were two salaries paid.
Yeah.
Chair, if I may
Yeah.
clarify. Both salaries were represented to the tax authorities. She paid tax on what was on paper on hers, and I paid tax which was on mine. The fault that I think we misunderstanding is that they split the salaries in two. But both paid taxes on those salaries.
Yes.
But it should not have been represented that way, I agree.
Yes. So in other words, the part of your salary
Yes.
that was paid to your wife, was it represented to the tax authorities as her salary instead of as part of your salary?
Correct.
And that was factually not correct.
Correct.
Thank you.
And you say that this was done in order to obtain tax advantages for tax purposes, your own words.
I took the advice from Dr. Jürgen Smith at that stage. Yes.
And of course, it doesn't take a tax expert to conclude that by splitting the salary, you would be taxed at lower rates, both you and your wife, than a lower rate than if you'd been taxed
That is correct.
on your own. Is that
That
correct?
is correct.
Okay. Let's move on then to the period 2004 to 2016. How was your salary paid then?
I'm sorry again, Mr. Pretorius. I don't know whether for completeness it's necessary to know what that salary was and how it was split, but you might,
That information will appear in the annexures.
later on. Okay, all right.
But we are dealing with rands and cents
Yeah.
in a minute.
Okay, all right.
Just explain what happened with your salary during 2004 and until 2016, please.
I wasn't comfortable with the arrangement of paying my wife. Besides, she was getting all my money anyway, Chair, like you. So, quite simply, I spoke to Dr. Smith. But more importantly, what had happened was they wanted us to split my salary because they had two companies, Concilium and Busasa, and the decision was from the management that they wanted to split my salary.
In addition to your income, in terms of your contract of employment, as you have described, did you receive other benefits of a monetary value?
Yes, I did.
What were these?
I would get cash bonuses, cash payments. I would get holidays. I would get gifts from Gavin Watson. I could go to a shop and buy myself expensive clothes, that type of thing, and I've listed them all.
All right, we'll come to the detail in due course. in relation to these benefits, including cash payments, did you declare these on your income tax returns?
At that stage, no.
The splitting of your salary, was that done for your benefit as opposed to the benefit of the company?
Chair,
Or both of you?
Chair, if I can answer that question, there would be no benefit to me. It would merely appear on the same tax number. The reason why it was split, I can provide you with.
Okay, all right. I guess that will be dealt with in due course. Okay.
Would you look at page 10 of the bundle, bundle S1? There's a table there. Would you explain that table to the chair, please?
Most definitely. If you look at the first column, it's headed tax year. The second column is headed annual earnings. Next to it is annual earnings of my wife, additional benefits and values. And unfortunately, it's such a long time ago, we had to estimate a lot of these. And then a cash payment received. And each year is according to the IRP5s as well that are attached here too.
So in answer to the chair's earlier question as to the details of the split between yourself and your wife, one can see those figures in the table on page 10.
Correct.
So, for example, during 1999, you are recorded as having earned 187,000 Rand, and your wife, that is D. Agrizzi, I presume,
Yes.
is represented as having received 400,000 Rand.
It's natural, I suppose.
Well, the implications are that your wife was represented as having earned substantially more, in fact, more than double what you earned.
That's true.
Right. When the cause of that income was your employment.
Yes.
All right. Then the column that is headed additional benefit and value, your estimates, or
Yes.
my estimates, my meaning Mr. Greasy's, those are approximate values of those benefits, holidays and house painted and the like.
Correct.
And these cash payments received are separate cash payments from all the other benefits in the table. Am I correct?
Correct.
And then if you go to page 11, the table continues to 2010, and the benefits include assistance vehicle trade-in. What is that?
What happened was I was doing a lot of traveling and I was working very hard. And the directors are all entitled to some sort of benefits and perks. And I was called in and I was told, listen, you're doing such a great job that we'd like you to upgrade your vehicle. And I was given the difference between the current trade-in and the new vehicle as a bonus.
Right. And the reference to the second-hand Audi Q7, was that a direct benefit?
Yes. What happened there was I was doing a phenomenal job apparently, and Gavin Watson had a Q7 in Port Elizabeth, and he sent it down to me and said I should take it over.
And then on page 12, the table continues to 2017. See
Correct.
that? And in 2017, the table records payments under the head annual earnings paid by Bosasa of 27 million. Am I correct?
That's right.
And
I'm sorry, Mr. Pretorius. I was wondering whether that's 27 million, the way those figures are. Is it? I'm not good with figures, but there's no indication anywhere that it's million, is it? I may be wrong.
Well, clarify, please. That figure in the table on page 12, under the heading Annual Earnings Paid by Bosasa in 2017, what is that figure?
That's a combination of the retention and the separation agreements. In other words, the agreement, the first agreement and the second agreement, which was paid in bulk.
And
What is the figure? I'm sorry, Chair.
The correct figure is 27,391,651. So it's 27,391,651 rands.
Yeah,
And
thank
in
you.
the next column, additional benefits and value, your estimates.
The estimates there are 22 million rand.
Now, were those amounts actually paid to you and received by you?
No.
Oh, you know what, Mr. Pretorius, what may have confused me is that in relation to the figures for the years before 2017, the way the figures are written is that there is -00 for cents, whereas in this one there is no -00 for cents. So that might have caused me some confusion. Thank you.
Okay, so to be consistent with the way in which the figures are portrayed here in this table, the figure 27,391,651 rand should have after it a hyphen and 2 noughts.
I've made a note of that.
But you say these amounts weren't paid, at least in full, and
Not in full at all. They reneged on the agreement at one stage.
were not paid at all.
No, I never said that. I said, Chair, that I can't remember exactly what was paid of the 22 of the agreement because that they did not pay in full.
Yes, some were paid, but not in
Yes.
full. Yeah.
Correct.
And the details we will deal with in due course.
That's fine.
The circumstances which arose at the time to cause the non-payment that you refer to, or the extent of non-payment that you refer to.
Correct.
All right. Let's just, having dealt with that schedule of income, deal with the structure of companies and briefly with the history of Bosasa, again by way of background. We do deal with certain factual matters in this section, but that's the way your statement has been compiled.
Before you do that, Mr. Pretorius, just so that for the sake of completeness, if I may go back to the position of your wife,
Yes.
is my understanding correct that in Diambo/Bosasa's books, she was reflected or would have been reflected as an employee, but she actually did not do any work. Is that correct?
Correct.
Thank you.
You will see, we may just note it, that the references to annual earning D. Agrizzi stop in 2004.
That's correct.
Let's deal then with the, and why did that occur? If you just explain again, you mentioned it briefly.
I was not happy about it. And they couldn't reflect my total salary because it would be an embarrassment to the other directors that were earning much less than I was.
All right. Let's go then to paragraph 7.
I'm sorry, Mr. Pretorius. It doesn't appear to me that it's apparent from pages 10 and 11 that with effect from 2005, she had fallen out of the picture.
If I may explain, Chair,
Yes.
if one looks at paragraph 10, page 10 rather, you'll see
Her name is there in
the headings
that
to
column.
the columns.
Yes,
Annual earning A Agrizzi, annual earning D Agrizzi.
yes.
That is the wife of Angelo Agrizzi. You will see that a figure is in the column headed D Agrizzi until the year 2004.
Yes,
If you turn the page, you will see that the column headed annual earning D Agrizzi has now disappeared. And it's now headed annual earning paid by Bosasa and annual earning paid by Concilium. I presume those amounts were paid directly to yourself.
Correct.
well, the difficulty with that, Mr. Pretorius, is that also the column written annual earnings A Agrizzi is no longer there at page 11.
Yes. All right, so let's correct
So
that.
there should be something that will tell the reader of the change.
Yes, okay. Let's just correct that then. The heading to the column on page 11, annual earning paid by Bosasa,
I've made a note.
that should be A Agrizzi.
Correct.
And in the next column, annual earning paid by Concilium, as you say in your statement, should also be reflected as paid in the name of A Agrizzi. Am I correct?
Correct.
Okay. Would that clear it up, Chair?
I'm sorry, it should be page 2, A Agrizzi in both columns at page 11, is that right?
Yes.
Correct, Chair.
Is that right? Okay. Thank you.
And
Then that will make it clear.
And if you look at paragraph 6.30.2, the position after 2004 is described there. Do you see that?
Yes.
All right. Let's then move to paragraph 7. The company that is relevant to your evidence that preceded the company Diambu Operations Pty Limited, and I must confess, Chair, I'm not too sure of the manner in which the corporate change took place, whether it was simply a change of names or a transfer of shares, but prior to Diambu Operations Pty Limited, what was the name of the company relevant to the Bosasa Group as it became known?
It was Meritum Hostels, Pty Limited.
Who were the shareholders in that company?
The shareholders there was Dr. Jurgen Smit and Mr. Fani van Sale.
And what was the business of Meritum?
They had a contract with a youth center, a youth development center, now called Mahale Youth Development Center. It was known then as Meritum Youth Development Center. It also had the Lindela contract, and undocumented migrants are kept there as they are today.
All right. Just before you go on, please, because youth development centers and Lindela are going to feature prominently in the evidence that you're about to give. What is a youth development center?
A
Who
youth
is it owned
development
by and what does it do?
Youth Development Center is where government pays us, the Department of Social Services pays Bosasa or Meritum, paid them a fee to detain a child that is awaiting trial. So they would pay a fee, and for that fee they expect quite a lot of services, training, development, cleaning, catering, laundry services, medical services, social services for the child. At Lindela, the provision is very similar, but more focused towards the adult, and all those services, with the exception of education, is paid for by government.
And what is the purpose of Lindela? What is its function?
To hold undocumented migrants before they get deported.
Did Meritum also provide catering services at mines?
They did.
And the corporate change that took place is explained in the last sentence of paragraph 7.1, where you say, I was informed by Gavin Watson that the shares in Meritum Hostels Pty Limited were sold to himself, that's Gavin Watson, Mansell and Diambu Holdings Pty Limited.
Correct.
And the business was then conducted by and under the auspices of Diambu Holdings Pty Limited.
That's right.
If you look at Annexure E1 to E2, and we need not go there for the moment, it's there for reference purposes, Chair, the structure of the Bosasa group of companies, its affiliates and associate companies as it appeared in 2016, the time you left Bosasa, is attached in Annexure E1 and E2. Am I correct?
That's right.
During the course of your evidence, you will refer to a number of companies and you will refer also to trusts.
Correct.
Their position in what you have referred to as the Bosasa group of companies in your evidence will be explained in those annexures. And if necessary, we can go there when that evidence is given.
Correct.
Did you compile that document?
I did not.
Are you in a position to verify that the information there is absolutely correct?
I have not been at the company for quite some time. I did not compile it. I don't know who drafted the document. I can't verify the veracity of that document.
So it's at best a guide for us, is it?
It is a guide.
That's at what page, Mr. Pretorius?
E1 is at page, page 247, and the further documents follow. So let's perhaps look at page 247. The Bosasa group structure appears on page 248. Do you see that?
I do.
And the company in the top left-hand corner of page 248 of Annexure S, or Schedule S1, or Exhibit S1 rather, is Bosasa Empowerment and Management Services Pty Limited.
Correct.
Its shareholders and directors, according to the drafter of this document, are set out there in that box at the top left-hand corner. And a subsidiary which is 100% owned by Bosasa Empowerment and Management Services Pty Limited is Bosasa Operations Pty Limited.
That is correct.
And its directors are set out there, and it's a wholly owned subsidiary of Bosasa Empowerment and Management Services. Is that so?
Correct.
And there are various related companies that appear on that page and following pages.
Yes.
We refer in this statement, or you refer in this statement, to, on the one hand, the Bosasa group of companies reflected in that annexure, and also to Bosasa. When you refer to Bosasa, to which company are you referring?
Bosasa Operations, the group.
Bosasa Operations.
Correct.
And that was your employer, I understand.
Correct.
Mostly. Concilium was your employer at a stage as well.
Correct.
With regard to the document at page 247, 248, the one that we have just had a look at, you have said that you did not compile it and you don't know who compiled it and you don't know if it's correct or accurate. And I assume you are talking about not knowing whether it's accurate as of now. As at the time that you left Bosasa, do you know whether this is how whether it reflects what the position was at that time or not?
Chair, my understanding is this was as it was then.
Thank you.
Right. From the annexure and your own knowledge, it seems safe at least to say that the parent company was Bosasa Empowerment and Management Services, Pty Limited.
Correct.
And within that structure, various other companies operated as part of the Bosasa group of companies.
That's right.
Was the position constant, and were the structures of the various companies and their relationship with one another constant throughout the period of your employment with Bosasa?
Chair, things would change very frequently. Directors would change. It was often difficult, very difficult to keep track of everything.
Did shareholders change?
Yes, they did.
You're going to refer in your evidence then to a number of companies. The first is Bosasa Operations Pty Limited, to which you've referred as your employer.
Correct.
Does that now have a different name?
It's now called African Global Operations, I believe.
You will also refer to the security arm of the group, and I understand to Bosasa Security Pty Limited. Correct?
Correct.
Has that name changed?
It's become Black Rocks Security Intelligence Services, Pty Limited.
Then, in relation to youth development, was there a separate corporate entity?
Yes, there was.
What was the name of that entity? What is the name of that entity?
The name was always Bosasa Youth Development Centers, Pty Limited, Chair.
In 7.2.4, you refer to Leading Prospect Trading 111 Pty Limited. What
Correct.
was the function of that company?
That is Lindela, that has the contract with the Home Affairs Department to keep undocumented migrants.
Who owned the Lindela facility? Or who owns
The
the Lindela
facility
facility?
where Lindela operates from is owned by Bosasa Properties.
But you say the operations are managed and the contract is held by a Leading Prospect Trading.
The operations are held by Leading Prospect Trading, and they are outsourced to Bosasa Operations accordingly.
Then in paragraph 7.2.5, you refer to a company to which you will again refer in your evidence, Sondolo IT Pty Limited.
Correct.
Is that now Global Technology Systems Pty Limited, also known as GTS?
I believe it is known as GTS.
Yes. What company is that, and what did it do?
That company has done quite significant work in terms of electronic surveillance and technology
Okay.
for the Departments of Corrections, Department of Justice. I don't know who else of late.
Right. And would you tell the chair of Pezulu Fencing Pty Limited, please?
Pezulu Fencing does high security mesh, welded mesh fencing, and it became known predominantly with the Department of Corrections contract as well.
That company does not appear on the organogram, I believe.
No.
But it is a company related to or within the Bosasa group of companies, am I correct?
It's related to because it's owned by Gavin Watson.
And then Concilium Business Consultants Pty Limited. Tell the chair about that, please.
Concilium Business Consultants used to be owned by the late Dr. Jurgen Smith, and I think his son had a small shareholding in that. And there was an agreement that Mr. Petrus Venter would take it over when Dr. Smith passed away. And he put it into his wife's name so Mr. Venters, so that it could not be linked directly to either him or Bosasa.
Now, you're going to refer to a number of entities in your evidence. Are you able at this stage to recall the full particulars and details of all these entities?
It's impossible, Chair. Impossible.
But to the extent that you can, you will assist the Commission.
Wherever I can assist, and I remember, I will tell you the truth.
Right. But the person with the responsibility for constructing the companies and their relationship with one another, I believe, was the company secretary at Bosasa, Mr. Tony Perry.
That's correct.
And he could assist, I presume, in any explanation that is required.
Yes.
All right. Chair, I see it's 1 o'clock. May we take the long adjournment?
Yes, no, that's fine. We'll take the lunch adjournment, and we will resume at 2 o'clock.
Thank you, Chair.
Thank you. We adjourn.